mis primeras palabras de agradecimiento al presidente del World Law Congress, Javier Cremades, y por supuesto también a Rainer Arnold por la invitación que me transmitió para participar en este panel como moderadora. También agradecer al catedrático de la Pontificia Universidad Católica de Sao Paulo, Marcelo Figuereido, de Brasil, que me acompañe en la labor de moderación hoy aquí. Decirles que me siento muy honrada de estar en Barranquilla, sobre todo para tratar en este congreso el tema del Estado de Derecho, la relación que tiene con la democracia como realidades complementarias, a sabiendas de que cuando hablamos de Estado de Derecho necesitamos no solo de las exigencias formales y procedimentales para su buen funcionamiento, sino también de exigencias materiales que van a tener necesariamente que ver con la protección de los derechos fundamentales. En este panel vamos a abordar, por tanto, dos cuestiones esenciales: la relación entre el Estado de Derecho y la democracia, por un lado, y por otra, cómo el Estado de Derecho debería ser considerado una cuestión esencial dentro del constitucionalismo universal. Desafortunadamente no están presentes ni tampoco online algunos de los panelistas invitados a este panel, pero en todo caso tenemos aquí en la sala a la mayoría de ellos y también a Jolita Miliuvine, que es la nueva presidente del Tribunal Constitucional en Lituania. De manera que para seguir dentro de lo posible el orden que tenemos programado y el tiempo de que disponemos, puesto que hemos ido con bastante retraso en el inicio de este panel, voy a dar la palabra en primer lugar a Gabriella Mangione. Bienvenida, Gabriella. Es catedrática de la Universidad Insubria y de la Universidad de Regensburg, professor at the University of Insubria como at the University of Regensburg in Germany. El título de su intervención es The Pandemic and the Rule of Law. Cuando quieras. Primero vamos a escucharte, Gabriella, y a continuación daré la palabra a Jolita Miliuvine. Si quieres.
Thank you very much I'm very grateful, I'm very happy to be here. Thank you to the organizer of this Congress Law. Thank you to Professor Arnold from Germany that has invited me here particularly. I will speak, I know we haven't got a lot of time, so I will speak about I will just give you some points. And the title of my contribution, as Professor Cristina Hermida said, is the relationship between the pandemic, we all know what it is, and the rule of law. As citizens, we all watch with concern what is happening around the world with the spread of this epidemic. Now there is the fourth COVID wave. We all know, we are very concerned. But as jurists, we have to observe the consequences, the repercussions of the measures to contain the epidemic, the consequences that the measure to contain the epidemic have on the freedoms, on the rule of law. There are consequences on the rule of law. The pandemic has affected people, has affected our human organism. We all know it, but the pandemic, the virus, has affected also the institution. There is a constitutional pandemic, we could say. So what has happened in my country? I will give you just some points. My country is Italy. At the time of this pandemic, especially in the first period, last year in March, when there was this explosion of the COVID. There are many institutional issues that we cannot analyze in depth here, but one particular I would like to, one particular stands out, and is the consequences the pandemic on the sources of law, which affects a rule of law. We all know that the principle of democracy gives Parliament the power to exercise and to decide whether, how, and to what extent it may restrict personal liberty. Who can restrict, who can limit our personal liberty? The Parliament, because the Parliament represents citizens. This is in a very simple, but this is the nutshell of rule of law. And what has happened in Italy, the controversial aspect, the negative, we would say, something that has raised a heated debate. During the pandemic, there has been a concentration of political power in the hands of the Prime Minister alone, not the government, the Prime Minister alone. First of all, we must point out that in Italy we don't have in our constitution the state of emergency. We don't even have the word emergency. This is different from Spain, where you have Article 116. I don't know the name the name is Stato de Alarma, Stato de Excepzione, Stato de Sitio, or in France, les pouvoirs exceptionnels. In Italy, we don't have the word emergency and we don't have exceptional powers. We have, in Article 78, the state of war, and we hope we will never use it, of course. But so we don't have instruments to face the emergency. And so let's start with this, with the endless discussions of the role of the Prime Minister alone. Prime Minister, our former Prime Minister, now we have another Prime Minister, now we have Mario Draghi, and I'm speaking about the Prime Minister during the first wave, that was Giuseppe Conte, and he enacted a lot of decree of the President of the Council of Ministers. This is the name. And these measures could not and should not regulate behavior that restrict constitutional freedoms. That's what the most of doctrine think. Why? Because the power to restrict, to limitate fundamental rights can be only exercised by law, as I said. We have a reservation, riserva di legge in Italian. Only the Parliament can do that. The Parliament or the government together enacting something that has the same level of laws. But the decree of the President of the Council Minister are secondary sources of law. They are not the same level of law. And that's why it has been, there has been a very huge debate on this. The decrees of the President of the Council of Ministers, of course, are faster, are more flexible, and they are instruments that can better face an epidemic. But the risk was and is to overexpose the person and the role of the President of the Council of Ministers. So there was a strong need to bring the emergency within the model of the rule of law, which is based, as we all know, on the principle of legality, separation of powers, and balance of powers. So, just to summarize, in Italy we have had during the pandemic, the first wave especially, a marginalization of the role of the parliament, and very too important role of the prime minister, as I said. So this decree, the decree of the prime minister, what are them? They are not laws. So there is no control of the parliament, there is no control of the president of the republic, there is no control of a constitutional court. Because in nature, these decrees are administrative acts. So you can go only to the judge. Of course, you can appeal the decree. You have the right to appeal as citizen, but before an administrative judge. So it's a very weak, they are very fragile. In any case, from the political point of view and from the constitutional point of view, these decrees, they have allowed the president of the council, the head of the government, to deal very fast with the emergency, but I repeat, there was a circumvention of the parliament. The parliament has been let aside, not for a week, but for many weeks. You know, in the beginning of the COVID pandemic, Italy was really in a terrible situation, especially Bergamo, in Lombardy, which is the land where I come, the region where I come from. Well, so from one side, we have had a very a strong criticism from the doctrine. The prime minister shouldn't have limited freedoms. On the other side, another part of the doctrine thinks that we must not forget the purpose why so many decrees that were limiting the fundamental rights. Why? What was the purpose? The purpose was to protect or to try to protect the health of citizens. We have an article in our constitution, is Article 32, that deals with the fundamental right of health. And the word fondamentale, in Italian, this adjective is used in our constitution only for right to health. But of course, all fundamental rights, are important. But there must be a balance between, there is no hierarchy in the rights, but there must be a balance. And I think in this balancing of rights, I think that everybody can admit that the balance at the time of pandemic weighs more in the favor of the rights to health. One of our former president of the Constitutional Court, Gustavo Zagrebelski, has written in 3 words, life, or 2 words, life first. There is a balancing among fundamental rights, but life first. And another professor, also with this side of the doctrine, said that freedom is very important, but freedom does not mean and cannot mean being free to make other people sick. So I can say, just to summarize, in the face of this health emergency, we are all inside this health everywhere in the world. In the face of the health emergency, there is a need to create a balance of powers, an adequate dialectic between government and parliament. So in order to derogate not too drastic manner with the fundamental freedoms and with the principle of rule of law. Thank you. Sorry, this is yours. Sorry.
Okay. Thank you very much, Gabriella, for your talk. Y si me permitís, ha puesto de relieve en su ponencia un asunto muy importante, que es el principio de separación de poderes, ¿verdad? Que parece haberse puesto en jaque con ciertas medidas restrictivas que se han tomado en determinados países desde el poder ejecutivo. Y bueno, pues vemos aquí cómo se siguen planteando nuevos retos que tiene que asumir el Estado de Derecho para seguir fuerte, ¿no?, en un estado de salud, nunca mejor dicho, el también favorable, ¿no?, dentro de la situación que estamos viviendo a nivel mundial con la pandemia. De manera que muchísimas gracias, Gabriela, por tu intervención. Y si me permiten, voy a dar la palabra a continuación a Marcelo Figuereido para enseguida cederle también el turno a la persona que nos está esperando online. Pero, por favor, me han pedido que hablemos porque si no, no se está grabando la imagen.
Muy bien. Muchas gracias. Muy buenas tardes a todos, todas. Estamos ahí con un retraso importante de media hora, 30 minutos, así que intentaré ser muy breve. No sé si tenemos imagen ahí, pero bueno, no me veo en la TV. En todo caso, vamos a, en primer lugar, decir que este panel tiene representados 9 países: España, Brasil, Moldova, Italia, Polonia, Luxemburgo, Rumania y Lituania. Aparentemente, sí, los países que están aquí hasta el momento, ¿no? Perú también, hay una inscrita de Perú. Así que tenemos 9 países representados. Como coordinador, bueno, me cabe también decir algunas palabras en no solo español, pero en inglés, ¿no? First of all, I want to initially thank the honorable invitation to participate on this magnificent 27th Biennial Congress of the World Jurist Association with this central theme: rule of law, development for nations, especially in the person of our president of this association, and also of Professor Reinhard Arnold. The decision to hold the Congress in Colombia, coinciding with the 3rd anniversary of its constitution, was very important. We have great respect and admiration for our Colombian brothers who have taught us a lot of perseverance to persevere in the path of the rule of law and democracy. There is no doubt that we agree with the organizers of this Congress when they say so. We likewise congratulate all the entities promoting and supporting this Congress. At the moment, it's up to us to moderate the panel together with my illustrious Spanish colleague, Professor Cristina Hermida, and I greet all the participants of this panel and all those present. Before that, however, I would like to establish a very quick idea of the concerns of the theme objecting of our meeting. As we can see in the program, the panel was very ambitious. It intended not only to discuss the rule of law and democracy, but also electoral system, electoral elections, campaigns, judicial control, etc., etc. Later, unfortunately, the focus has become a little more clear. It calls for some analysis on the relationship between the rule of law and democracy, and whether the rule of law should be considered a universal attribute of constitutionalism. En otras palabras, el Estado de Derecho es un concepto hermano de constitucionalismo o no. ¿Hasta qué punto el Estado de Derecho es un concepto universal de su relación con la democracia? Este es el panel que va a tratar esto. No voy a adelantar nada por cuenta del horario, solo por ahora, agradeciendo nuevamente a los participantes, llamarle el próximo panelista, que en nuestra lista es la profesora Agnieszka Jen.
No, disculpa.
No.
Me piden expresamente que cedamos la palabra a Yolita Miliubine, que está conectada online y se tiene que retirar.
Ah, muy bien. Entonces, por favor, ¿a quién? ¿A Milán, Christoph? ¿No?
Yolita Miliubine.
A Yolita. Perdón. No sabemos de estos detalles informáticos. Entonces, vamos a invertir la orden, porque la primera orden era que hacer los presentes en primer lugar y después los que están de lejos de acá. Pero bueno, vamos ahí entonces a pasar la palabra a Yolita Miliviene, que es asesora del presidente del Tribunal Constitucional de la República de Lituania, investigadora de la Universidad Nicolas Romeris de Vilnius, advisor of the President of the Constitutional Court of the Republic of Lithuania. Welcome to Professor Yolita. You have the floor for 7 minutes, and I ask you for at least made it in 5 if it's possible. Thank you very much.
Okay. Hello. Thank you very much for the floor and for your understanding, for letting me speak now, because I'm in fact in the middle of the other event, and the time planning was strict not only in your conference but here in Europe as well. I will speak today also about some threats to the principle of the rule of law, some threats leading even to the constitutional crisis, but not related to the pandemic, as Professor Gabriella has spoken. Nevertheless, I think they are not less important. And as the time limit is very strict and there are a lot of panelists to speak, I will stick to my paper more than usual, if you permit me, in order to respect the limit of time given. Only the state acting under the rule of law, the law which respects and protects the fundamental human rights and freedoms, might be considered as democratic. The differences to the content of the rule of law and the variety of the constituent elements of this principle in the different legal systems is the cornerstone of every constitution. Therefore, the respect for and the implementation of this principle should be an essential objective. The principal guardians of the rule of law are the constitutional court or the equivalent constitutional control institutions, entitled to verify the constitutionality of legal acts adopted by the legislative or the executive. The constitutional control ensures that the state power institutions would be accountable to the law, which is consistent with international human rights standards. Essentially, the most modern constitutions reject the parliamentary supremacy in favor of some form of constitutional review, ensuring the better protection and the implementation of the principle of the rule of law. Unfortunately, the recent constitutional crisis in Europe and beyond reveals that the guardians of the principle of the rule of law, the constitutional court, sometimes need the protection themselves. Then one might raise the classical juvenile question of who will guard the guardians then? Only genuinely independent and strong constitutional court can duly perform its tasks of controlling the state power institutions and ensuring that the requirements of the principle of rule of law and of democratic elections have been respected. Therefore, the independence of the constitutional court has a twofold importance. It is an inevitable part of the rule of law, and also is a chance to protect the rule of law and all its constituent elements. Without effective constitutional control, the state powers institutions would find themselves free to adopt any legal act, knowing that the act won't be repealed, or they might be feel free to legitimate any elections derogating from the traditional understanding of what the democratic elections is, which actually has happened in Poland and Hungary, and not even mentioning the Belarus or Russia, where the constitutional control institutions were overwhelmed and weakened by the interference of the political powers. Analysis of such situations proves that the threat and the weakening of the constitutional control institutions is the red flag for the appropriate implementation of the principle of the rule of law. In the chapter regulating the functioning of the constitutional courts, in all constitutions there is the provision stipulating that the justices of constitutional court, while in office, shall be independent of any state power, office, organization, or any person. However, the absence of direct interference with the work of constitutional court and the absence of direct pressure on how to resolve the constitutional justice cases doesn't mean that there are no threats to the independence of the constitutional court. The recent constitutional crisis in Europe shows some lessons and permits to distinguish the following threats to the independence of the constitutional court. First of all, the restrictive amendments to the legal regulation concerning the functioning of the constitutional court, or even limiting the competence of the constitutional court. But the changes in legal regulation are easier to spot, easier to identify, to attract the international attention, and to permit to apply all kinds of boosting measures inviting to comply with the requirements stemming from the rule of law in order to restore the violated independence of the constitutional control institution. The second threat, and it is a bit more complicated, is the struggles to the process of recomposing and the renewal of constitutional courts, which also might be of two main reasons. A, when the subjects entitled to participate in the procedures of the appointment of constitutional justices deliberately violate the rule of this procedure, acting ultra-vires or ignoring the limits of their competencies to choose the candidates or appoint the justices in time. Therefore, at the end of the proceedings, only the candidates loyal to the state powers institutions are appointed to the position of the constitutional justice. And the second reason of the struggles of the process of appointment of constitutional justices are the following. The subjects entitled to participate in this procedure acts within the limits of their competencies, but intentionally fails to coordinate their actions among themselves when there is a few institutions participating in this procedure, or fails to find the agreement on the most appropriate candidate. Therefore, all the process fails and the constitutional court becomes the hostage of the miscommunication of the state power institutions. The disrespect of the procedure of the appointment of constitutional justices might have severe consequences on the functioning of the constitutional control institution. As the multiple example shows already, it might lead to the constitutional crisis of the whole state. The failure to appoint a new constitutional justice in time might paralyze the whole work of the constitutional court if the law doesn't have the safety catch provision permitting to justices whose term of office has expired to continue to fulfill their functions, like such paralysis happened in the Slovak Republic, or the inappropriate rotation of constitutional justice might raises the question of the legitimacy of the institution itself, presupposing that such an institution of constitutional control doesn't meet any longer the criteria of the tribunal established by law, which is the example of Poland, and I think it will be approached in more details later by the panelist professor from Poland. And even the rotation fails not because of the violation of the procedure rules like it was in Poland, and even when there is that safety catch provision that I'm mentioning before, the unlimited term of offices of justices cannot be regarded as legitimate if the constitution provides differently, which had happened the last year in Lithuania, and in fact the pandemic was indicated as the cause of the non-successful rotation of the constitutional justices. So the pandemic was in some some kind related to this, but the process was not completed for 1.5 years maybe, and it was some grounds to be considered about it. And because without the alleged constitutional control, the state is not democratic. Any state is not democratic anymore, and when it's not ruled by law, when the rule of law is not protected. And in closing my short speech, I must admit that unfortunately today I don't have a clear answer to the question who will guard the guardians of the principle of the rule of law from political interference, inter alia, to their appointment procedure. Although this issue, I think, merits the proper attention in order to deepening the constitutional crisis all over the world, and in the same token, in order to avoid the disrespect to the principle of the rule of law. The possible key to the solution, in my opinion, might be the procedure with the least possible political involvement, which is not plausible now because in all the states the justices of constitutional court are appointed by politics. And the second thought might be the introduction of judicial body in this procedure, still absent in the majority of cases. With this I'm finishing, and thank you very much for your attention.
Thank you.
Thank you.
Thank you. Muchas gracias. Thank you very much, Professor Yolita. We are on time. Now, I'd like to call the floor. Gustaría de llamar para nuestro panel al profesora Agnieszka Kalala de Polonia, es catedrática de la Universidad de Torun, el profesor University of Torun. Él hablará sobre la democracia y el Estado de Derecho y liberal en Polonia. She will talk about democracy and rule of law, illiberal in Poland. Please, you have the floor, Professor, for 7 minutes. Thank you very much.
Thank you very much. Thank you for the invitation and for the organization of this panel. I am honored to be here and to have this opportunity to speak about, yes, exactly the rule of law and democracy in illiberal Poland. So I will try to be very brief. I have 3 points and a conclusion. I would like to start with the question or with describing what and when happened. Since 2015, Poland, following Hungary, started to transform its constitutional system into a liberal one. Obviously, we were not first and we are not last, as some elements of illiberalism we can find in Romania and in other states that have this post-Soviet past or history. As for the system, illiberal constitutionalism, it is based on liberal constitutionalism elements. But instead of democracy, we have a majoritarian vision of democracy. It is not inclusive. Elections are free, but they are not fair, as media freedom is at the lower level as it was before. We have also defective legislative process, but I don't want to specify this subject. As for rule of law, we have in illiberal Poland, we have illiberal legality, which is connected mainly with judiciary that is less impartial and less independent. And for the Constitutional Court, we can say that it is not impartial, and it is connected with European Court of Human Rights and its decision in Xeroflor case. If we consider human rights protection, it is diminished. I would like to provide here two examples. It is abortion case that provided for almost total ban on abortion. And then we have also the decision of the Constitutional Court, which say that the Article 6 of European Convention on Human Rights is not conform with Polish Constitution. And the last element of illiberal constitutionalism, it is constraint on public power, and what we can see that constraining effect of EU law and international human rights law is getting less and less powerful. So I would like to, in the second point, I would like to say that those elements are interconnected or mutually connected. So if we have some concerns within the rule of law, like for example, the effective judiciary, then democracy is also endangered, and it is connected, for example, with election, as Supreme Court, according to our constitution, has a power to decide on validity or legality in the electoral process. And so for the effective judiciary, it has also impact on human rights that is less protected. And yeah, so individual is not protected against arbitrariness of rulers or those in power. So the third point, we have three examples of our latest concerns that are connected with democracy and the rule of law. I would like to recall here the extra-constitutional emergency that was provided and bypassed the constitution. And we have attacks on LGBTQI people, and it is connected with citizens' initiative, and also such things are connected with women's rights that are diminished. And to conclude, I would like to pose a question. So how much democratic and rule of law oriented state should be to stay within constitutionalist group of countries? And if we think about Poland, so Poland has been hit or has hit the wall already, especially if we consider doubtful developments in relation to the EU law and also in relation to the human rights law. So how far are we, Poland and Poles, from authoritarian regime? I can say that we are very close, and we still support autocrats. And this is the real thing, that it is more about people than institutional settings. And thank you very much.
Thank you very much. Muchas gracias, profesora. Parece que tenemos muchas cosas en común entre Polonia y Brasil, porque también vivimos un régimen iliberal con un presidente iliberal en este momento, ¿no? Con violaciones a derechos humanos, conductas claramente antidemocráticas. We live in Brazil with a very common situation with very much similarity with Poland, because we have a president now that runs the power with a lot of illiberal powers. I mean, he is clearly against human rights. Anyway, thank you very much, profesora Hermida.
Muy bien, pues gracias Agnieszka for this interesting talk. And our next speaker is Luis Claudio Alemán, President of the Chamber of Conciliation, Mediation and Arbitration of the Federation of Industries of the State of ES, Findes, Vitoria, Brazil. The title of the talk is democracy and the digital area. Thank you, Luis Claudio, for being here, and you can begin if you want. Thank you.
Thank you. Good afternoon, Barranquilla. My subject, democracy in the digital area. I would like to thank to Professor Heiner and the organizers for the invitation for participating in this prestigious legal event. Thank you very much. Great all in the people of the moderator Cristina, Hermida, and Marcelo Figuereido. I will make a presentation on the importance of personal data protection rules for the fundamental rights of a participatory society in the information age, which has a concept, a mode of social and economic development where information plays a fundamental role in the production of wealth and the improvement to the quality of life. Brazilian social data, before the pandemic, demonstrate how the protection of personal data is important for democracy, as social media has not yet been learned. Brazil had 134 million internet users and 99% access via a smartphone. 89% of the population between 9 and 17 years old were internet users in Brazil. Maybe 24 million people access through cell phone. And the total numbers of the functional illiterates in Brazil, totally 38 million Brazilians. This is the profile of your society connected to the internet. Consumer information, producing and expressing its opinion, including positive fake news, that is, delivering your personal data or metadata so that they can be produced and used in different ways and for different purposes. To understand this new society, it is important to visit the work of Francis Fukuyama in the book, The Great Disruption, Human Nature and the Reconstitution of Social Order, published in 2000, where the author asks the following question: Can information age democracies maintain social order in the face of technological and economic change? We live in a moment of demand for the hyper-connected society, which form a large network, which, in the word of dollar rate, there are no possible excuse for not listening to society 24 hours a day. Thus, the challenge of your times is to ensure that the same society maintains its freedom to express itself or society network, but at the same time, prevent public management from moving towards populism. In view of the Brazilian membership present, it is important to ask the first question. Were personal data protection laws born with the aim of guaranteeing freedom, privacy, secrecy, independence, human dignity? We can elaborate another question based on the statement of Amartya Singh, professor of Harvard University, who, using an economic concept, stated that democracy is not based on a secret ballot and the freedom to choose a candidate. Thus, transporting Singh's statement to digital area, we can elaborate the second question. Are personal data protection laws designed to allow citizens freedom of choice of a candidate, ensure that there will be not citizens' vote being conducted of a candidate because of metadata manipulation through the algorithms of electoral marketing companies? These are two questions that make us reflect on the guarantee of fundamental rights and the democracy in the digital area, from different points of view and interests, but both converging to maintain the activeness of free nations. I conclude by quoting James Bartlett, author of the book, The People vs. Tech, How the Internet is Killing Democracy and How We Save It. Says Bartlett, we need to take care of our behaviors online. It is more important than vote. But the But the first thing we need to understand is why we were so naive in the beginning. Thank you so very much.
Bueno, muchas gracias al profesor alemán por su interesante intervención. Thank you very much, Professor Alemán. Well, now we have called the floor Professor Milan Christoph, que es adjunto al abogado general del Tribunal de Justicia de la Unión Europea, referring there of Advocate General of the EU Court of Justice. Professor will talk about EU law versus national law and the protection of the rule of law. You have the floor, Professor, please.
Buenos días, muchas gracias, es un placer estar aquí y muchas gracias a mi amigo Rainer, Professor Arnold. So I am very happy to be here. I will talk to you about the rule of law protected on the national scale and also at the national, supranational level. So basically the conclusion of my talk will be that the rule of law exists also at supranational level, at the European level. And the universality of rule of law is present not only, so it's present not only in national law but also on supranational EU law, and that's what proves the universality of rule of law. So the rule of law is protected under EU law, and that proves the universality of rule of law. And why am I talking about this? The problem is that in September, in the opening session in Regensburg, I spoke about specific cases where the Court of Justice ruled mostly on cases involving reforms in member states of their judiciary. And so these member states, they come and they say, well, this is nothing for the European Court of Justice. This is an internal matter, how we reform and organize our justice. And yes, that is true, but as I will explain in my presentation, the problem is that the rule of law needs to be protected at national and European level, and basically, so you cannot just defend yourself by saying that this is none of your business, because I will show you that this is very related. And basically, in Article 2 of the Treaty on the European Union, the treaty says clearly that the EU is based on shared values. These include democracy, protection of fundamental rights, and the rule of law. So these shared values obviously need to be also protected, and the protection of these shared values is also shared between the EU and the member states. So the rule of law is integral not only to the democratic identity of the EU and of the member states, but it's also essential for the EU to function, and it's also necessary, the rule of law is necessary so that citizens and businesses have faith in have trust in public institutions. And obviously, if you have deficiencies in the rule of law in one member state, then that will impact other member states, and it will also impact the EU as a whole. So basically, I am building on my presentation in September, as I said, where I spoke about these specific cases of the reform of judiciary. And you see also in that situation that the rule of law is taken very seriously by the EU, and it's highly, EU is normally highly viewed in protecting its rule of law, but you see that even in the European Union there are issues, and we need to be vigilant in protecting the rule of law. The effective legal protection has been a general principle, has been declared general principle by the Court of Justice already in the 80s, but now we have the Article 19(1) second paragraph of the Treaty on the EU, which says that member states shall provide remedies which ensure effective legal protection in the fields covered by EU law. And in that respect, I would like to talk to you about a very important judgment from 2018, where the Court of Justice ruled in the so-called Portuguese judges cases. And it was for the first time the Court of Justice fully recognized the very important role of national courts in the EU constitutional order. So in that case, in the Portuguese judge's case, the Court of Justice interpreted this Article 19 as a self-standing ground of assessment of national measures and in their compatibility with regard to requirement of judicial independence. In the Portuguese judge's case, it was general salary reduction measures, and so this was attacked that these general salary reductions for judges were impacting the independence of the judiciary. And so the Court of Justice built on its previous case law and linked clearly the existence of effective judicial protection to the rule of law, and so declared that the effective judicial protection is the essence of the rule of law. And so the Article 19 gives concrete expression to the value of rule of law in Article 2 of the EU Treaty that I mentioned at the beginning, the shared values of the EU. And so that's why the court says that both the national courts and the European courts have a shared responsibility of ensuring effective judicial protection. And that's why the national courts have to share the task of the Court of Justice. The task of the Court of Justice is to ensure in the interpretation and application of the EU treaties that the law is observed. And so the Court of Justice says this is not just my job, it's also the job of national courts. And that's why in the Portuguese judge's case, the court says that this is why you cannot just say that how you organize your judiciary is an internal matter, because the Court of Justice says, you know, the national courts also need to be independent. And so you can organize your national judiciary, you know, it's your right as a member state, but you need to respect certain safeguards and you need to respect EU law. And so when member states are reforming their judiciary, they must respect EU law. And so from the institutional perspective, it's important that the judges and the courts are independent, because the independence is a conditio sine qua non for the functioning of EU and also of the judicial protection in the EU. And there was already an argument that I liked in the academic literature that said that basically the national judges cannot wear two hats. Reminds me of these sellers of hats, of straw hats on the beach that you see also here in Colombia, that wear, you know, many hats that they are selling. So the point is the national judges cannot wear two hats. They cannot say, you know, when I'm wearing my European hat, I'm independent, but when I'm wearing a national hat, I can be not independent, and vice versa, you know. So basically that's why there is this unitary nature of the independence of the judiciary. It's based on the broad application of this Article 19, and that's why the Court of Justice makes clear that certain institutional guarantees must be satisfied by national judges, including judicial independence. And that's why I think that the rule of law clearly exists not only at the national level, but also at the supranational level, at the EU level. And that's why I think that the rule of law under EU law is a proof that there is a universality of rule of law. Thank you for your attention.
Muy bien, muchas gracias, profesor, por su intervención sobre la importancia de la independencia judicial, no solo en nuestra región, pero sobre todo en la Unión Europea. Para nosotros también es una importante lección la independencia judicial. Nosotros que tenemos algunos problemas graves de sistemas autoritarios en América Latina, la última puerta para bater sin duda es la justicia, ¿no? Así que the independence of judicial power is fundamental, it's a pillar of the rule of law. Thank you very much, Professor. Professor Cristina, it's your turn. It's your turn.
Bueno, pues muchísimas gracias por esta última intervención. La verdad es que estoy actualmente formando parte de la Comisión de Ética Judicial en España y me consta que hay muy buena relación con la Comisión de Ética Judicial Iberoamericana. trabajamos y colaboramos estrechamente y, por tanto, me gustaría transmitir este mensaje que se ha señalado hace unos minutos de lo importante que es que se preserven los tres principios dentro de lo que es el cuerpo del Poder Judicial, ¿no? El principio de independencia, del que se ha hablado ya, de imparcialidad, no hay imparcialidad si previamente no se es independiente, y el principio, no menos importante, de integridad moral que tiene que tener el juez. Luego, junto a estas virtudes éticas, como decía Aristóteles, hay también virtudes dianoéticas, es decir, virtudes intelectuales que tienen que tener los jueces, juezas, magistrados, magistradas, y tiene que ver con cuestiones tan importantes como también el desarrollar la virtud de la prudencia, la sagacidad, la empatía, ¿no? Y sobre todo mantener siempre el principio de igualdad entre las partes dentro del proceso. Por tanto, me gustaría por eso insistir en esta cuestión que me parece fundamental para que el Estado de Derecho se mantenga incólume. Y para terminar, si me permiten, me gustaría terminar con tres ideas que señalaré en inglés, puesto que había preparado un speech, pero no hay tiempo para ello, y que son las siguientes. Democracy without the rule of law is empty, and the rule of law without democracy is blind, which means that democracy must be at the same time substantial and formal. Also, a perfectly constructed legal system of legality does not guarantee legitimacy if it does not promote the relation to effective justice. And the third one, the rule of law is not an immutable legal structure, but rather depends on its development on the continuous action of us, of the citizens. In summary, the rule of law constitutes an area of dialogue, debate, and rational confrontation between social projects for the reform of existing institutions. Thank you very much. Muchas gracias por la atención.
Muchas gracias.